Oui, je vis en Angleterre, mais en fait, à l'origine, je suis lyonnaise. J'ai fait mes études ici, sauf que la Manus n'existait pas, c'était la droit. Et puis après, c'était les quais, donc en troisième et quatrième année. Donc ça a bien changé depuis. L'idée, et comme vous, pour certains d'entre vous, en tout cas, j'avais fait un échange, effectivement, j'avais bénéficié de l'échange avec Boston University. Et puis après, c'est un peu le hasard, je suis allée en Angleterre et je devais ne pas rester pour 2 ans. Et finalement, et ben voilà, je suis restée. Donc me voilà ici. Et l'ironie de la chose, c'est que je fais tout en anglais quand je suis ici. Donc j'ai 16 heures de cours et c'est 16 heures en anglais. So the idea today is to introduce English criminal law. That's it. And to do so, you more or less need a good introduction, quite a solid introduction in the sources of criminal law. So some of it will match what you've done in first term with Simon Wesley, with the equity and common law and the doctrine of precedent, the role of the statutes in Parliament, as well as the techniques to interpret legislation. But it's not to repeat what you've done, it's just to show you how it impacts on criminal law. English criminal law has its roots in the common law. And that is absolutely fundamental because you still have offences that are purely common law based. They're not defined in any statutes. So you have to remember that everything you've learned about precedent and the role of the courts is still absolutely valid. Yes, you have a codification movement in the 19th century that started in the 19th century. And yes, you do have more and more legislation, but it remains a subsidiary tool so far. It's just becoming, it's not the primary, it's just becoming nearly equal now with the common law. So that shaped criminal law very much because the principles of criminal law are not in a code, they're not in statutes, they're more or less case law based. So common law based. The most serious offences, murder, manslaughter, so murder, l'homicide intentionnel, manslaughter, l'homicide non intentionnel ou involontaire, they are not statute based, they are purely defined by the cases, okay, so by judges. Assault and battery, c'est l'équivalent des coups et blessures volontaires ou non intentionnels, ça dépend, mais dommages minimes. Most defences are still not defined by Parliament. You've got a couple of them now coming in. There is talk about codifying, so putting them on statutes, but you still have a lot of offences, a lot of defences that are just simply outside the statutes in common law. Which means that it has also another impact. So it's not simply, if you like, where you found the information and the sources of law for whatever you're looking at, offences and defences. It also means that you had a piecemeal development. So a development that has no coherence. They didn't think through the coherence. So fraud developed only in the late 18th century, didn't really exist before. And the statutes are not necessarily well thought through in terms of how they match or overlap and so on. The other aspect is that it's incremental, so little by little. And it's particularly true for the elements of the offences like intention. The definition of intention is more or less a series of cases, and you have to understand what is the cases, what they say, the limits of what they said, and so on. So you actually depend very strongly on procedure. Because if you have cases like on intention, what is intention and what it is not, it depends on the type of case, it depends on who was saying what. Is it the jury, is it the judge? Because if you have murder, rape, as much as manslaughter, you will have juries strongly involved, and they decide on facts, but the facts shape the legal questions. So very, very important to also understand the sentencing powers of the judge, because it shaped, for example, the defenses. Some of them emerge because of the constraint of the sentencing powers. We'll see that. And obviously, everything that you've learned about the doctrine of precedent and how it was, and statutory interpretation remains important. And the main thing to remember is that you're in the United Kingdom. Yes, we're looking at English and Welsh law, criminal law. It's not Scottish law. But you still have two main Supreme Courts, the UK Supreme Court, SC, and the Privy Council. Okay. There is a case very recent which I also sent to Gabriella, so you can have it on Moodle or your platform. It's two cases, one by the Supreme Court, one by Privy Council. And the Privy Council is because the facts happened in Jamaica, in the Caribbean islands. And it's still a reality of English criminal law as much as of English law. Okay, so you may have cases that are Privy Council, but they are still perfectly valid in English and Welsh law. Now, the fact that it's common law based has also shaped the interpretation of what it means to have legal certainty. You know, the basic principle of criminal law is that normally everything has to be stated before the law can be applied, and it has to be stated in clear terms and available to any potential offenders. So how do you do that when it's the common law, and that by definition certain elements of an offence will only appear or define more precisely through case law? Okay, because you don't have anything to relate to by statute first. So I'd like to, and it's probably going to take us about 10 to 15 minutes to go back on the concept of legal certainty and doctrine of precedence, partly because it reminds you of what you've done, partly because it will need it after. So what I like to start with is Blackstone. Blackstone, he is the first one to have more or less written about English law, not simply English criminal law, but English law. It's the commentaries, and you have 6 or 7 volumes. They are all online now. You've got a website that's printing them, and they're all available online. And those commentaries restate, obviously, the offences available at the time, but also the principles of criminal law, as much as the legal system, so doctrine of precedent. So the quote that I do like, because I think it gives an idea of what is the doctrine of precedent and how they view the possibility of changing things. It's for an established rule to abide by, it is an established rule to abide by former precedents where the same points come again in litigation, as well as to keep the scale of justice even and steady and not liable to waver with every new judge's opinion. It is not in the breast of any subsequent judge to alter or vary from, according to his private sentiments. He's been sworn to determine, not according to his private judgment, but according to the known laws and custom of the land. The main issue with that is you have two issues. First is where the same points come again in litigation. Okay, what does it mean in criminal law? Of course, if you've got the concept of intention, which is the one that creates the most problem, or you have the concept of a conduct. What is an omission, for example? Can we accept omission as a conduct for criminal law? you know, what is it? Do we take into account the facts of the case? Do we say that if the facts are not the same, then we're not obliged to follow what has been decided? And then the other aspect is according to the known laws and customs of the land. Well, it's a bit of a fiction because obviously if you had nothing, then the judge has to not simply interpret or declare the known laws and customs of the land, but actually to create. So those aspects are the tensions, if you like, are in that Blackstone extract of, well, the judge officially just interpret and declare the law. The reality is that there is a much bigger power. The other quote, which is a bit earlier, but I think in terms of principles and understanding, is the one of Justice Hale. So that one is better here rather than before. And it gives you a very good idea of actually how the common law functions. So at the time, you know, it was the high society, and high society knew their Greek as much as their Latin. They knew the Iliad and the Odyssey. So Argonaut Ship is about the Greek myth and the fact that the boat goes away for 20 years or so and then comes back. So they apply that story to the common law. So it's quite striking by Justice Hale saying there are the same English laws now than they were 600 years since in general. But like or as the Argonaut ship was the same when it returned home as it was when it went out, though in that long voyage it had successive amendments and scarce came back with any of its former materials. So what it's saying really is that tension between the fact that officially it looks like being the same, it's the common law, it's not changing that much. In reality, bits and pieces are created along the way and added. And that meant a lot for criminal law. We'll see it later on. The other tension in, and that has a direct influence later on criminal law, is that was the common law with Blackstone and Hale, and you could add Cook, Edward Cook. But you have Bentham in late 18th century, early 19th century, and Bentham was very much opposed to the common law. For him, it was a symbolic of complete legal uncertainty, and we should never use the common law. It should disappear. We should replace it with codification and codes. Mind you, Bentham didn't like the Napoleonic Code. He considered it was the worst possible specimen that you could create. He had his own vision of codification, but it's that notion that we should not have the common law. He even wrote to the US when they started to have the independence war to say, please, while you're independent or while you're setting up for independence, please don't continue with the common law, just adopt codification. And the US did partially that because they actually, for everything that was criminal law, they all put it in the code or in the Constitution for the big principles of criminal law. So he had an influence. And his influence was indirect. He died very young in 1930s. And the movement of codification in the UK, in England, was after that. But his philosophy was continued by John Austin. So John Austin is really the very late 19th century. It's like the two extreme of the 19th century. And he was very, very harsh on the common law because he considered it was the childish fiction employed by our judges, that common law is not made by them, but it is a miraculous something made by nobody existing from eternity and merely declared from time to time by the judges. Okay, but if you remember that sentence from Blackstone saying that the judge declare all the known laws of the land, well, they're not written, so how do you know them? You can understand why it has that conception and that concern about the common law. And it's true that at the beginning of the 19th century, it was a system, especially for criminal law, that was a complete mess. I mean, comparison with today, it was a real mess. Equity, obviously, it's not criminal law, equity, but a lot of the cases were simply not finished, took 30 years. If you read Dickens, Bleak House, have you ever read it? The beginning of Bleak House is with a trial, and the trial in civil law just lasted 30 years. And it was so bad, and that's the original text, it's not me translating in French. It's the original legal French, Oyez sans terminer. Okay, so that notion that it was heard, but it was never completed, and the judges in equity never gave the final decision. And it was really, really bad. It's not an exaggeration. Dickens actually took what was really happening. Common law, the main issue, and it was particularly problematic for criminal law in terms of legal points, is that you have a very confused procedural review. So you had appeal, you have writ of error, you have 3 courts that could have jurisdiction. So it was quite confusing. Decisions of the House of Lords as Supreme Court were not published until 1812 on a regular basis. More or less what was before 1812 was in 6 volumes, and 6 volume was after 1812 about the next 3 years. So a real increase after that, but it means that before that the law was more difficult to know, and therefore Blackstone, for example, commentaries on English criminal law was the main source of reference, just to understand what was what. And obviously there was also a questionable decision process before the House of Lords, before it became independent in 1824, because the politics, so the lords that were not the law lords, could intervene. So a real problem, and it led to 3 movements, one of them being specific to criminal law. The first one is rationalizing the judiciary. So they started to look at the courts and the way appeals were done, and the way what to look for in the first instance, first degree. So starting to rationalizing it. And then at the end of the 19th century, the merging of equity and common law. The second is codifying statutes. And that was especially true for criminal laws. It's still mainly about the larceny act. So larceny was theft. But the reality was a lot of things linked with theft. It was theft with aggravating circumstances. So you have burglary, you've got robbery, you had deception, so that was the fraud offense. It was really much, it's worth looking. They are available on the internet, the larceny acts, and it's worth looking at the structure. More or less what it does is that it is presented as codifying. The reality is that it restates the definition created by the judges, and it doesn't really change the law. It's just restated and put it in legislative form. And the third series is the doctrine of precedent in 1861, saying that the House of Lords is bound by their own cases and not simply the inferior courts like the Court of Appeal and the High Court. So the main outcome of this tension between the common law and legislation, so what is the role of Parliament, in the 19th century had been codification of important aspects of criminal law. Now, not everything, because murder is still not codified, manslaughter is still not codified, so the most serious offences are still not there. Rape was codified, and the last legislation is 2003. So this is quite important to understand, because we'll see it later with criminal law, what it means in terms of the leeway, the margin of appreciation that the judges have. I'm not going back on this. You should have seen it first. It's civil law, it's not criminal law, about the doctrine of precedent. The House of Lords accepted to go back into on its own cases. And it's the notion of declarative theory that was also very much believed in England to characterize the common law, which is really strange because in comparative law theory, we always say the common law is judge-made law. But the English absolutely were convinced that it was not judge-made law. They were declaring the law that was pre-existing. And that really changed in 66. But in 66, if you really look at it, it went back on the possibility of having overrulings. So the possibility to change for the House of Lords its decisions. And the center was that notion of certainty, but it's never complete. So you still have that tension there. There is no clear fixed terms for overruling. Too rigid adherence to precedent may lead to injustice in a particular case and also unduly restrict the proper development of the law. That is about the criteria found for overruling. The problem in criminal law is that it doesn't give you much information. So what does it mean specifically for criminal law? Well, you still have the main offenses that have not been created by Parliament. And the question is, can the judge create new offenses? Well, in theory, yes. In theory, you've got common law and there's no issue. In practice, well, you've got very, very few creation of offenses today. The last one was in Shaw and DPP in 62, and it was the recognition of the offense of conspiracy to corrupt public morals. Public morals is more or less the equivalent of the famous civil code sentence of Article 6, les bonnes mœurs. So recognition of the offense of conspiracy to corrupt public morals. Conspiracy means simply having an agreement between two people or more. You don't need to do anything else than having an agreement to corrupt public morals. And the court justified the creation of the offense. Well, they said that the offense existed because you could see it in, if you like, social constraints. But it's the last time that really the courts decided that you could have an offense. You do still have other possibilities to create criminal law, not by creating offenses, by widening the scope of its application. So you can do that by creating offenses, but you can also do that by enlarging the conditions for liability, either for the principal or for the accessories. Les accessories, c'est les complices, la complicité. The accessories liability, normally, it's the same, to be honest, the Greek principles are exactly the same as in French law. Accessories liability follows the principal's liability in that you need the conduct and you need an intention. But in 1985, by Privy Council, PC is Privy Council, House of Lords in English and Powell, 1999, the two courts decided to enlarge the notion of intention. So intention, which has never been defined in any statute in England, has been defined for accessories as having foresight. So I'm not giving you here the details. You don't have to remember the details that intention is foresight. Donc foresight, c'est simplement la capacité d'imaginer que quelque chose peut arriver. D'accord. What is interesting is that power is considered as existing and can be used. And when you had it overruled in 2016, literally a month ago, okay, that power to modify things at common law without any statutory basis has not been contested. It was within the jurisdiction of the courts to change the common law in a way which made it more severe. Okay? Remember that normally in criminal law you need to make sure that when it is more severe, the law is known beforehand, and normally it does not apply retrospectively, it applies for the future. The problem with common law is that by definition, if it is the judge that says so, it will apply for the case. So it applies retrospectively. But the court did not contest that power. It was not an issue. The outcome was an issue, but not the power, the principle of it. For that, I'll repeat it later on, but it's, I think, really, really important. In that case, Joggi was Supreme Court and Ruddock was Privy Council. Ruddock was from Jamaica, Joggi was English. So very few offences now are created. The extension of criminal liability, the power theoretically still exists, but it's less and less used. And it also means very few overrulings. Okay? In the tradition of the doctrine of precedent, English criminal law doesn't like to have too many overrulings. And to be honest, especially with that last case of 2016, the trend is to have an overruling when it is to diminish the scope of English criminal law, so to have less criminalization. So overruling will occur to diminish, to reduce the scope of criminal law. That was the case for C and DPP, with the House of Lords refusing to abolish the presumption that children cannot be criminally liable between 10 and 13, and they considered that Parliament should deal with it, but not them. On the reverse, R&R, and we don't know the name of the plaintiff, also called the marital exemption case. What happened is that the interpretation in the common law has been that husband and wife, and that is at civil law base, okay? Husband and wife in civil law, English civil law, were merged. They were making one entity. It was coming from an interpretation of Christianity, and that notion that the wife is more or less invisible and she only exists through her husband. Okay. Obviously, with society changing in terms of how the relationships between husband and wives, this became unacceptable. But the translation of that vision in criminal law was until very recently, so 1992, a husband could not rape the wife. Okay, the idea is that when they married, and it was husband and wife, so it wasn't linked with just being partners. The idea was that between husband and wife, when they married, she consented to sexual activity with her husband, and it was like a virtual consent for anything at any time, okay, without being renewed. That came from that English civil law perception of what a marriage is. It translated in forbidding rape, not recognizing rape between husband and wife. That was changed in 1992, and it was absolutely very clear that they were equal partners, and that's why they should have the change. Now, in terms of legal certainty, okay, and in terms of changes, because more or less the husband went to the court thinking he could escape liability, and the court said, well, we're not having the marital rape exemption now, we're going to allow liability. It therefore went to the European Court of Human Rights, and the European Court of Human Rights confirmed that there was no violation of its Article 7, that notion that you need to know the law beforehand, especially in criminal law. So, and the reason, if you read the House of Lords case, which is available free of charge on the internet, it's because the change could be foreseen. We could anticipate the change because society had made, since the 1970s, more or less husband and wives equal in civil law, so it should translate in criminal law. But this is typical of the common law reasoning about criminal law and how it should be dealt with. Now, this last case, 2016, I will send it to the EDC because I want you to read it. 37 pages, okay? That may sound a lot, But I will give you the paragraph that you really need to look and that you can understand. It's one of those recent decisions that is absolutely wonderfully written. It's really well written. There is no dissent and there is no concurring opinion. So it's very rare that you have a whole court of 5 judges writing the same thing. Okay. So that in itself is really important. It also indicates the importance of the case, because there's no dissent, no concurring opinions. But the case has several aspects. You have the aspects of legal system as much as criminal law and the definition of intention. But what I like here is that notion that the judges discuss at length why they wanted to have an overruling, why they want to go back on what they used to have. And they give reason. It's a 3 pages on the reasons of why they want to change the law. So our analysis leads us to the conclusion and introduction of the principles. So the principle at stake that they want to reverse was based on an incomplete and in some respects erroneous reading of the previous case law coupled with generalized and questionable policy arguments. Okay. We recognize the significance of reversing a statement, so it's an overruling, of principle which had been made and followed by the Privy Council and the House of Lords on a number of occasions. We consider that it is right to do so for several reasons. And then they go on, and I'm not quoting everything, I'm just giving you a couple of them. First, that the law is highly controversial and led to a number of appeals. So highly controversial, source of difficulty in applying, large number of appeals. This is the heart of the definition of what is uncertain. So it's the exact opposite of legal certainty, if you like. And that's why they want to reverse it, to create certainty, to make things clearer and therefore less subject to appeals. The second thing that is interesting in terms of sources is that secondary liability, so the liability of accessories, so les complices, la complicité, is an important part of the common law. By that, they meant it's an important part of the case law. It's not statute-based. And if a wrong turn has been taken, it should be corrected. Okay? Well, part of secondary liability has a statute, but the core definitions are not statute-based. They are case-based. And I skipped a little bit, but the 5th one is the reason it's because intention was interpreted in such a way that it was a lower requirement than for the principle, and that's why they wanted to change it. So it's really important, and being English, they actually raised the point in relation, well, why should you do it and not let Parliament do it? Why do you have to change the law and why it should not be Parliament? Especially in criminal law, maybe we should have Parliament. And then we can anticipate and comply with the main principles of criminal law of not applying a law retrospectively for the past situations. So they raised that in paragraph 85. As to the argument that even if the court is satisfied that the law took a wrong turn, any correction should be now left to Parliament. The doctrine of secondary liability is a common law doctrine put into statutory form in section 8, and if it has been unduly widened by the court, it is proper for the courts to correct the error. So it's really that notion that the court made a mistake, the court repair the mistakes. It's not the Parliament that necessarily has to intervene. Of course, if Parliament wants now to intervene, they can. They could, for example, Parliament could, for example, abolish this, which is quite old now, and restate all, the definitions and the elements, the conditions for secondary liability. But the court is conscious that it doesn't want to wait until Parliament intervenes. And the effect, and they're quite clear also on the effect. You have a whole page on past convictions, and it's titled Past Convictions, because they knew that if they changed the law, they would have probably a lot of appeals by defendants who've been convicted on the the old principles of intention and say, oh, look, my case, I was wrongly convicted, my decision needs to be quashed, that notion that the decision needs to be stopped, to be overruled. And, therefore, they are thinking, well, if we overrule, then we're going to have a lot of appeals and a lot of decisions contesting previous convictions. And the court is particularly clear, even though it's only one page. At the very beginning is the effect of putting the law right is not to render invalid all convictions which were arrived at over many years by faithfully applying the law beforehand. And what the court is saying is don't count on the overruling to appeal from your conviction, because your circumstances probably will still match the new test, the new principle, and you will not be released and your conviction will not be overruled. So it's very important in terms of legal systems and how it affects criminal law and how it is done. Now, you still have challenges from time to time about that uncertainty. You have the recent case of 2004 about gross negligence manslaughter. So what it is c'est l'homicide involontaire, donc non intentionnel, avec mise en danger. C'est juste le niveau mise en danger, pas mise en danger délibérée. And gross negligence manslaughter, it's purely common law. You've got no statutes, absolutely none. The elements is in a famous case called Adomako. It went to the Court of Appeal, which can be the Supreme Court, and it more or less said that there is no issue about legal certainty and the convention. The law was predictable, and to be very honest, the case law in gross negligence manslaughter is particularly clear. So we know exactly the elements of it. You had the same case for another offense about the common law offense of public nuisance contrary to the common law, 2005. It has never been presented, well, it was in the digest. Stephens is a judge of late 19th century. Apart from Blackstone's, the next book is Stephens. He has about 6 volumes of criminal law. And there was the offense of public nuisance contrary to the common law, except it stopped being used for about a century. So when they revived it in 2005, the argument was, well, it has never been used for more than a century. The law is inadequate, it's not clear, it's not certain, and the House of Lords considered no, everything was perfectly fine. There is no issue about legal certainty. So you can really see here the power of the common law in creating offences or maintaining offences and shaping the scope of liability. Now that said, you still have statutes. So even though I insisted a lot, and we just spent 37 minutes on this, you do have a strong movement of codification. So it started in the 19th century, as I said earlier. So on that side, it hasn't changed. It has accelerated, I would say, over the past 30 years. For general principles of criminal law and offences and defences, for example, provocation used to be the common law defence. It's been completely reshaped by the Coroners and Justice Act, section 54 to 56, on the loss of self-control. A lot of strict liability offences, donc les infractions matérielles, vous savez, celles où il n'y a pas besoin de prouver l'intention. Il suffit d'avoir la conduite, donc de commettre l'action. Most strict liability offences are now at statutory level, and the Home Office as well as CPS have given guidelines to try to avoid common law offences as much as they could. The main thing is that for murder, manslaughter, they can't avoid the common law. Okay, but they're trying to, for any other type of offences, to try to see if there is not a statute can be found. So there is that sensation now and that feeling that the common law, yes, theoretically it can create offences, it's perfectly fine, but there is that feeling that we need to have now statutes if possible. Now, the way they conceive statutory instruments and statutes is very, very different from the French vision. There is no general code. Okay, so you never have a code pénal qui fait à peu près comme ça. Hein? It was the idea in 1985. They proposed the vision of a criminal code in 1989. It's simply never been implemented, never reached the parliamentary stage. And actually, that's the next slide, it's been abandoned. But the main thing I wanted you to remember, we'll come back on it, is the Law Commission. So the Law Commission, it's an independent body, the Law Commission. You don't have the equivalent in France, okay? But the principle of the Law Commission is to review areas of laws that are problematic. So it's a review, and the report can be 300 pages if necessary. They publish their report. They have a consultation phase. So the report is published. Anybody can answer the consultation, including individuals. So you can give your opinion of what is good, what is not good. So it can be academics as much as practitioners, judges, and so on. And the idea is that they review what they call the evidence through the consultation process, and they rewrite the report, the original report. And in some cases, they will amend their recommendation, they will change. Those reports is like a book on the problem. They are high quality. At least half of the members are lawyers, and they're chosen for their known excellence in the area. So they're recruited by field, criminal law, civil law, you have commercial law, property law, and so on. But they are, if you like, the people who are the most knowledgeable in their field. So currently, you have, for the Law Commissioner for Criminal Law, so the head of the Law Commission in relation to criminal law matters is Professor Omrod. He is a barrister, which is typical of England. He is also an academic professor. But it is typical of criminal law, where a lot of academics have been barristers before or have practiced as solicitors. They're not necessarily straight coming from their PhD and with a PhD. Actually, I don't think Omrod has a PhD. And he wrote the key book in criminal law. The book is big like this, okay? The code in France is important. This is more important than anything else. And it is absolutely symbolic for me of what is happening and the way criminal law is shaped today. The book, we call it, my colleagues and I tend to call it the Bible. It's because it's absolutely superb criminal law book. It has all the principles, but with a lot of practitioners' view. You can see the practitioner insight in it. Especially they argue, and that's where, remember the beginning of the slides, they argue the jury-judge point of view. So the procedure, how the procedure is going to influence the elements. So go and have a look. Everything now is online on the Law Commission. They actually hardly print anything. And it's absolutely crucial to understand the role of the Law Commission. It's much better than in France, les comités qu'il peut avoir en Assemblée nationale ou au Sénat. C'est des vrais rapports faits par des juristes, des professionnels du droit, et ça se sent. So the Law Commission, I told you the last 30 years, because I didn't put certain statutes here, but in Computer Misuse Act, donc le droit des nouvelles technologies, it was the Law Commission report in 1989, and it gave the Computer Misuse Act 1990. But the recent ones is the Fraud Act, completely changed. The Corporate Manslaughter and Corporate Homicide Act, Serious Crime Act on complicity and other aspects. Criminal Justice and Immigration Act, which abolished blasphemy and criminal libels. Donc, la diffamation n'est pas une infraction pénale maintenant en droit anglais. Ça l'était, et encore c'était très restreint par rapport à ce qui se passe en droit français. C'est uniquement une matière civile. Coroners and Justice Act for loss of control, provocation, defense. And we have coming in the sentencing code, and it is called a code. Okay, so that's important to notice. It's Omrod who is pushing for it. I have to say that it's not something I do usually sentencing, but they managed to find that they have 1,300 statutes on sentencing, and it works the English way. So you've got statute number 1, gives a sentence. Statute number 2 says that something like section, so paragraph 45 of statute number 2, it modifies half of a sentence in statute number 1. Okay, and then that statute number 2 is modified by statute number 3, except that you need to do the chain. So you need to look at statute number 3 to look at statute number 2, and then statute number 2 you need to make sure you can check with statute number 3. But you've got literally, you have no book putting all the statutes together in a logical form like you would have in a code. In the code, if you open Légifrance or your Code d'Alloz, you would have inserted the different statutes, and you have it. It's visible. Okay, I'm not saying sentencing is easy in France, but here, 1,300 statutes, to the point that even the House of Lords commented to say that it is not legible, not readable. They cannot find the sentencing, and they are not sure when they sentence people that it's the correct sentence. Okay, so it's an enormous task, but the Law Commission is very keen on it, and I think it shows a lot about the way English law proceeds in terms of statutory reforms. The other report, which is fundamental because I'm hoping, cross fingers as we say, to have a new statute. It's the offences against the person, so everything that is non-homicide, so les coups et blessures volontaires ou non intentionnels. It's an old statute currently, 1861. It's completely outdated. It's based on the case law. The case law is unclear, and it's a mess. To be really honest, even the Law Commission said it was a mess. Cross fingers, it will translate in statute. But it gives you an idea of how the legislation can shape, and how even legislation is in itself insufficient to comprehend and to understand English criminal law. The last thing on this, on the sources, and then I'll give you the break, is to understand the relationship in terms of what the statute creates and how the judge interprets. The first thing is that Parliament is presumed not to have any intention to change the common law unless it says so. So if Parliament is, for whatever reason, not clear, the common law will stay and will just add another layer with the statutes. So that is really absolutely fundamental to remember. And the second one, the second rule to remember is the interpretation rule of mischief. A statute is supposed to be interpreted in relation to its objective of modifying a problem at common law, but nothing else. So it's very important. Oh, I didn't delete that one. I thought I did. Well, in a way, it's important. Because of that, and because Parliament has to make its intentions very clear, parliamentary statutes tend to be really long. Critics said wordy. To give you an idea, the defense of loss of self-control, donc la défense la cause d'irresponsabilité liée à la perte de contrôle, qui n'est pas nécessairement la contrainte. C'est en partie la contrainte, mais pas nécessairement. It takes 3 articles, 2 pages. If you take the French code, it's 4 lines. That's typical of the way a statute is going to be drafted, and it leads to a lot of questions about the wording used and so on. But it's typical. Another dimension of this is that the statute was meant to replace provocation, and provocation, so it was accepted as a defense, donc comme cause d'irresponsabilité, that if you were provoked because of sexual infidelity, you had the right to kill your partner who was not faithful. More or less, that's what it meant. And the statute parliament really wanted that to stop. So they banned sexual infidelity in one of the sections, in section 55(6)(c). The problem is that you've got a Court of Appeal judgment of Clinton, and it reintroduced it. It more or less used the old common law of provocation to introduce the possibility of being excused for sexual infidelity. So to be excused in killing somebody because the person, the victim, was unfaithful. So it's typical also of the problems created of that interaction between common law and statute law. You have also issues with Computer Misuse Act, but I think I'm going to leave that one. Computer Misuse Act was enacted to combat hacking, so that notion that you access a computer without authorization. And hacking, typically, we think of one computer accessing a second computer. And the question was literally asked to the court, do we need to have 2 computers to have unauthorized access, or can it just be one computer which is accessed without authorization? And it went to the court to say, well, actually, any computer means a single computer. You don't need a first computer to access a second one. Okay? And unauthorized access, the question was, what does it mean? Not having access at all to the computer or the device, or not having access to certain part of that device, or for certain purposes. And the case was about police officers using their access to databases for private purposes. So they used, the car registration number, la plaque d'immatriculation d'une voiture. Ils ont utilisé, c'est tout sur banque de données, ils ont utilisé la banque de données pour rechercher par rapport à leur vie personnelle et non pas à leur vie professionnelle, donc par rapport à leur métier. Et ça a été considéré comme un authorized access. Mais il a fallu aller devant le juge pour avoir ça. Voilà. Et ça, c'est un problème qui ne se pose que parce que le juge, à l'origine, n'a pas cette notion d'une interprétation de l'esprit de la loi à une interprétation de la loi littérale. Hein, le literal rule and mischief rule and nothing else. Okay? Not the spirit of the law. So, you're going to have your break. Right? 5 minutes? 5-10 minutes? Okay? Et on recommencera avec la procédure cette fois, parce que ça aussi, il faut comprendre.